All right, good afternoon, everybody, and thank you for joining us for a discussion today on internal and third-party audits. We'll go through and discuss some of the risk, rewards, and some suggestions on how to best protect the results. I will be your host for today. My name is Nick Scala. I am the chair of the practice group here at Conmasi Al-Kheri. I work with mine operators all over the country, be it whether they are production operators or independent contractors working on mine sites. I assist in representation through litigation in front of the Federal Mine Safety and Health Commission, as well as managing inspections and investigations. And another part of that is managing third-party audits for companies. So that is something that we are going to be discussing moving forward, and I hope everyone can hear me. I'm seeing some feedback that maybe that isn't the case. So 1 second, let me try and check that out. All right, it seems that it is the audio is working for most people. So if you are having trouble, I'd recommend trying to call back in. I'm sorry for any problems that are maybe out there. But, to look over what we're going to cover today, we're going to talk about some types of audits, and that is really just going to be, are we going to look at internal audits, meaning we're doing them ourselves, or are we going to have a third party come in and do that? We're also going to look at what are some of the risks and the benefits of these. Obviously, the benefits are clear when we're evaluating our workplace for potential safety and health pitfalls or violations from a compliance perspective. But there are risks that we need to be aware of and that we should be prepared to address, or at least take some action to protect our results. And that's because MSHA can get a hold of them, as well as other third parties in terms of civil litigation. But for the purpose of what we're going to talk about today, we're thinking about how can MSHA get these records, and they can request them, and they can because they are discoverable, if not privileged. And then finally, we'll discuss, how we can go through that privilege process, and if we still want to do an internal audit, some tips on how to craft our audits and some language that we can use to maybe help us if MSHA gets the records down the road. So some obvious rewards from doing an audit or a safety audit at any time is we gain information about our site. We gain information as to where we might have some conditions that need to be addressed, or maybe we observe areas that are not in compliance or maybe are in compliance, but we think that greater care should be put into making them even safer or improving them further. And these audits are a great tool in evaluating that, because we shouldn't be waiting for the twice or 4 times a year that MSHA is required to show up and do an inspection. And also, at that time, we are in the position where we can get citations. And obviously, no one wants to be dealing with citations and orders when we don't have to. And in time, then we can review everything and go through and see where maybe more attention is needed is this safety audit process. Additionally, these audits provide a great deal of information for training and for improvement areas with the workforce. And that doesn't just mean replacing a guard or rebuilding a berm that may be below its required height. But also, when we do these safety audits, we should be looking at, and we want to be looking at, the behavior of the employees. Do we witness people doing unsafe things? Do we witness people doing things that are contrary to their training? So they might need to be retrained. These are all areas that should be covered and can be covered in this audit process while not getting a citation for failure to comply. And that is obviously a great benefit. Many companies do this, whether they are looking at having someone from their own plant do it, or we can have someone come in from another plant if we have multiple facilities in our company. And that is a helpful tool if we want to do an internal audit, but we're looking to get a new set of eyes on the situation. Also, if we're bringing in a third party, whether that be from within or outside the company, there's no vested interest in that employee saying that their work site was already in pristine condition or already was in as good of a condition it's going to be, because we know that when we look at something every day, when we work in the same area every day, we kind of go blind to maybe situations that we don't usually address. So maybe in that specific work area or in our specific quarry, we have a set of hazards that are most likely to occur, whether it's spillage or it's a certain piece of equipment breaking that could cause a potential hazard. We might just tailor what we're looking at for those specific elements. And that really doesn't help when we're trying to do a comprehensive safety and health audit, and we want to be able to get a more broad perspective of what could be in compliance and what may not be in compliance. There are certain benefits to having a third party do it, and whether or not that's one that you contract out, so a consultant of some sort, or if that is simply bringing in people from a different facility, or maybe even if you have a large enough facility, bringing in people from a different part of it. I recommend, even if we're doing internal audits, that we try and get a new set of eyes on each area. We're not doing the audit by having the same manager who does the complete inspection every morning or every afternoon do it, or the same person who does a workplace exam. We want to get someone out there who has maybe not seen the area so that they can look at it in a more holistic or a more complete approach. Additionally, if you are going to engage in a third party, there's a benefit that their job is to come out and give you a complete result. And that result isn't going to be prejudiced in any way by them not wanting to get in trouble by what they're reporting. That is a very important aspect, because we want to have a complete record if we're going to go through this. We don't want to be shortchanging ourselves in the process by putting people in a position where they don't want to tell us maybe what they found wrong or maybe what they found to be inadequate, because they, fearing that there might be repercussions. So that is an important element for getting, whether a third party or someone else from a different site, and especially outlining that, this is for the safety and health improvements of our facility. It is not for disciplinary purposes. Now, if it leads to determinations or it leads to the observation of unsafe practices, obviously we have to address those in a different way. But there are great benefits to looking at it and just finding out what maybe aren't we seeing on an everyday basis. In terms of risks, there are, obviously risks when we're doing this, because we're broadcasting what may be potential violations. We are broadcasting and we're creating a written record of what at least what our point should be, is document unsafe conditions or potential hazards. Maybe something that isn't a hazard now but could be a hazard later. And the reason that this is a risk is because if we're not protecting these, we are opening ourselves up to potential exposure and MSHA getting their hands on that document later on. And this, is a problem, especially when we're dealing with fatality investigations or hazard complaint investigations that might, hint at the company was aware of a specific condition, or the company should have been aware of a specific condition because they did this audit process. When we're dealing with MSHA, a big part of it, and maybe the biggest part of it, when we're determining the severity of a violation, is the employer's knowledge or the operator's knowledge of said condition. Another way that there is a risk is if we don't take action quickly to remediate any findings from that report. So, that is, if we're going to do it, it's a great tool, but we can't just sit back and say, well, we'll get to this next month or we'll get to this next week. We need to quickly evaluate what the findings are. we need to quickly look at, what we can do to make these improvements or protect the miners from any of these potential hazards. And that could be by barricading an area or ordering materials or, correcting it or correcting the hazard altogether. But we need to take those affirmative steps quickly. It's much like when we do a workplace exam and we find a potential hazard that needs correction. We need to take prompt action on that. And now that's not included in the existing workplace exam rule, but it is, prompt notification of miners of potential hazards is something that is in the new rule that could go final on October 2nd. So like that, though, we must take prompt action to correct any of these findings from an audit. And, so the question is, why might MSHA could have come across these, and why does that even matter? When we are dealing with OSHA, there's a statute of limitations that you have a 6-month date or time frame to issue violations from the initiation of a inspection to the end. Well, we all know that MSHA is a strict liability statute. And if you've been on any of the webinars previously, I touch on it almost every time because it's an incredibly important aspect of our work environment and our regulatory environment. The strict liability means that we are going to be responsible, regardless of fault, for anything and everything that occurs on our mine site. And additionally, MSHA has no statute of limitations on when a violation occurred and when they can issue a citation. So, not to scare anyone, but these results, if they find that there was a fatality that occurred or a serious injury, and they find audit reports that are 6 months, 8 months, maybe even a year old, and they could obviously go back further if they so desired, and they find that you had notified in that this hazard that caused whatever injury or complaint that we're dealing with was mentioned and discovered at that point in time, and we did nothing to abate it, that can be used against us in terms of negligence. That can be used against us in the determination of a normal failure. It is a high bar, and it's also a strong tool that they have, and that if we don't take the correct action, whether that is abating or it is marking down why we did not abate a certain condition, it can be used against us. And that's another reason why I would recommend that we look at how can we protect ourselves from this coming into MSHA's hands in terms of a privileged audit. So while these aren't required records, and that might be what some of you are thinking right now, well, these aren't a workplace exam, these aren't training documents, how can MSHA get their hands on them? Well, there's several ways. MSHA can get their hands on them because they are relevant to their investigation. And, we can push back on the production of non-privileged audit records by saying they are not relevant and they are not a required document. And, that is a route you can go. But if you do this, especially if anyone's ever been through a complaint investigation or an injury or fatality investigation, we know that MSHA is very much in a get information now mode, and that they're also of the mindset that any information that is not immediately provided is because you're trying to hide something. And while that may not be true, it's how they're going to look at it. And it's how many of the inspectors are going to proceed, that you are trying to impede their investigation. And that is a pretty serious claim and a pretty serious action that MSHA can levy against an operator when they feel that they are not providing the relevant information or that they are not providing relevant documents that they know the company is in possession of. And that's something that they can issue under Section 103A of the Mine Act. And when they do this, obviously it is going to, carry possibility of agent liability investigations, as well as other ramifications that we just don't want to get into that because it just makes it muddies down everything else. It can, somewhat create a position that have even more contention between the two parties. And that's never going to be a beneficial thing when we are going through an investigation. Obviously, we never want to have MSHA out on site more than they are required to be in terms of the enforcement actions that they can put down. But when they are on site, obviously having a good relationship with them and not having a contentious relationship with them is ideal. We want to be able to talk with them. We want to be able to work with each other. And a lot of times I've seen that these kinds of requests for records that aren't specifically required, but MSHA is aware that we have and that we maintain, are specific pitfalls, are specific areas where we can get into a bit of trouble with them. So what happens if we don't issue them? Well, MSHA does not have subpoena powers to request documents, but they can issue these these impeding the investigations. They can issue unwarrantable failures. They can even issue 104Bs. There was a case in a coal mine that a inspector and in the course of a discrimination investigation, their supervisor were requesting the entire employee contact information for all employees at the mine. And the mine kept pushing back and saying, we're going to provide you with the information of the employees who worked in the relevant areas. And MSHA kept saying, no, we want all records, all records. Well, eventually, what they did is they issued a withdrawal order, a 104B, for the entire facility for the company failing to provide the requested information. And that was taken through significant litigation because the company said that you cannot issue this withdrawal order unless we are in violation of abating a standard or failing to abate a specific violation or a hazard to miners. And the commission actually granted the MSHA the power to do this, to shut down operations essentially until they get what they want. And it's a scary proposition, it really is, but it's all the more reason why we need to do everything we can beforehand to make sure that our records aren't going to put us in a bad position, and as well as, if we can, to privilege them and protect them. So even if our records, say we get through this investigation and MSHA says, okay, fine, these aren't required documents, we're not going to push you on it, does that mean you're out in the clear? Well, if they're non-privileged, it does not. Because even if they are not collected by enforcement personnel, unless they're privileged, they are going to be discoverable in litigation. Meaning that if the enforcement personnel, in the course of talking with their attorneys from the solicitor's office, say that, hey, they have these safety audits, and we think that these safety audits are really going to be an important tool for us or going to carry a lot of information, you can receive a production of documents request specifically listing those out, and they will be discoverable. Now that's, something that doesn't happen too frequently, but it is something that can happen, and it most certainly can be a way that they obtain these records. So we want to keep that in mind, and we want to keep that in mind throughout this process because, again, when we're looking at the language and what we're identifying and what we're doing or not doing, we want to be able to have a clean rationale, or at least an established rationale about what was done, what wasn't done, and why. And what we talked about before is, when would they request it? Well, we've kind of covered it, but it's really, these aren't something that we typically see MSHA court requesting during a regular health and safety audit. If we're just going through that, I know a lot of operators conduct these regularly. I know a lot of MSHA enforcement inspectors know that operators are conducting their own internal audits, be it from people coming in from another site or just doing them on their own at the same site. And they typically don't dig into them. But like with most things in MSHA, we really don't realize how far the rabbit hole can go until we are under a investigation of some sort. And again, that can be a hazard complaint or an injury or fatality investigation. And that's really when we get into, the questions of task training. People often ask, where does task training end? And it may never be an issue during a regular inspection whether or not someone had training on a specific task, because maybe it wasn't a area that inspector or the enforcement personnel really paid attention to. Did you task train them how properly to climb a ladder and get on top of that piece of equipment? Well, that is going to come into effect, and that is going to come into question when you have a hazard complaint or an injury, because the adequacy of the task training is going to be called into question. And similarly, that's when we're going to see them dig deeper for more documents. We're going to see them looking at, what is out there that proves that the operator should have known that this condition existed, or that the operator did know that the condition existed. And that's really important because we're looking at the negligence. And as I said before, negligence is, from the enforcement perspective, one of the most critical items that MSHA is looking to check off their list. They want to know, did the operator know or should they have known of a condition? If we look at MSHA's definitions for negligence in Part 100, obviously there's no negligence, and that one is pretty self-explanatory. But then when we get into low, moderate, and high negligence, the definitions are the same with the exception of the final words in the phrase. And that is, the operator knew or should have known of the volatile condition, and there was either considerable mitigating circumstances for low negligence, mitigating circumstances for moderate negligence, or no mitigating circumstances for high negligence. And so when they are looking at that, they're looking to find information that would show that there's no mitigating circumstances. And that doesn't even go into the question of reckless disregard, which is just the operator did nothing to correct a known hazard, and as a result there was some type of injury, or the hazard was just very much out in the open and the operator should have done something. But for the purpose of looking at mitigating circumstances, MSHA will look to, how obvious was the condition. They'll also look to, did management have any reason to know that it existed, or did it develop in the course of the shift, or were management not informed of a particular condition based off of the actions of minors? We see that frequently when MSHA issues citations, whether that be for items that weren't listed on a workplace exam or on a pre-shift evaluation of a piece of mobile equipment, or maybe they were listed but the individual didn't turn it into management or to someone who may be in a position to take action. In those situations, MSHA is going to evaluate what the knowledge level of the operator was. And these internal audits or third-party audits can contain that piece of evidence that makes MSHA say there's no mitigating circumstances here. You knew that this was a hazard. You had seen it in an audit the last 3 months or the last year, or it was on the last 2 reports that you should be correcting this, and there's nothing here that says why you didn't correct it. So, you are now highly negligent, and there's no mitigating circumstances that can support the existence of this alleged violation. And, that's what we're looking at. We're also looking at MSHA issuing unwarrantable failures. Unwarrantable failures are also known as 104Ds, and they can be withdrawal orders for an entire piece of equipment or area or type of action at a mine site. And when evaluating that, MSHA is going to look, they need to have high negligence for the initial unwarrantable failure. They're also going to evaluate how long a condition existed. What was the operator's knowledge? What were their efforts in abating or their lack of efforts in abating? And also, had they been placed on greater notice that care was required or greater efforts were required for compliance and safety? And that is really the bigger one when we're looking at how does this relate to what we're talking about today. And were we put on greater notice that greater care was required? And that's what these audits are going to do. That's why we want to do them in the first place. to understand what could be a hazard, where those hazards may be, so that we can take action to correct them. But just know, by failing to correct them, or if it's a widespread issue and we've corrected it on one location but haven't bothered to look at all the other ones, this could still be an area where MSHA comes to get us, or can try to come to get us through use of these audit records. So now that we know all the bad things that come from doing this, how can we protect it? What we want to do is, if we're doing our own records, if we're doing our own reports, we really want to focus on language. So we don't want to be saying that this item is a violation or this item is a hazard. We want to say that these are recommendations, or that we are reporting the findings that this could be improved. We want to use improvement opportunities, something along those lines that just kind of don't jump out when an inspector is reading them that this is a violation. I've seen operators who have prepared reports that are very detailed, but in it they list the alleged violation or the area that they think needs improvement. They include a picture with the words violation, and they've even included a standard. And while that might be helpful from an education purpose, it's also helpful to MSHA if we go back in and they get access to these records. So we want to try to protect ourselves by removing anything that could show that this was a violation, or that this was something that was going to be imminently dangerous to health or safety, those kinds of catchphrases that we are probably well used to hearing if we deal with MSHA. We want to avoid using those in our own reports, because we don't want that to come back and be a red flag if they ever are reviewed by the agency. Also, we want to look at using the phrase required in our reports, because while a report may be done, we don't want to necessarily say it's a required action, because when we want to have time for our management to come in and review it and determine maybe this isn't a required action, maybe there's another way that we can improve this condition, or another way that we can avoid this condition altogether without doing what is suggested in the audit report. And so that is something that we want to also stay away from, is just the term required. Essentially what I'm trying to get around is we want to avoid at any time cementing our position on a particular hazard that could be deemed a violation, or could be deemed a volatile condition later on by the agency. So in order to continue this, we want to make prompt corrections. Okay? An audit, really, it's hard to say the audit's going to hurt you, other than proving that something existed previously if we took corrective action. Obviously the mining industry is a dynamic environment, so the same guard might break twice in a day, it may break twice in a month or a year, but if we've taken action to correct it, that should not be used against us. And the same can be held true for the results of an audit program. We want to take action to either correct it or list why we are not correcting this recommendation, so that it is not looked at something that was just overlooked or ignored later on. We don't want to get in a position where MSHA can say you knew about this and you did nothing. Well, we didn't do nothing. We evaluated it. We determined that there was a different way to approach it, or that it was not a hazard as the auditor believed it to be, and we moved on from it. Or we took action and we corrected it by doing A, B, and C. We want to look at those to say that we took action. We did not just sit back and wait for MSHA to come out and find it, or wait for anything else to happen with it. That we were proactive, not only by conducting the audit, but by acting on what the audit found. So this, though, when we look at getting into more protections on the citation or on the audit reports, the best way to do this, and I say best, but maybe the most prudent way to do it if we are really looking to protect our records is engaging outside counsel. This grants you the ability to exercise certain privileges that attorneys can have with the records. And, that is, it now becomes an attorney-client communication, which is privileged, because we would be reviewing the audit report and providing you recommendations and compliance advice based on that. It was also created at the direction of counsel, and it's also considered to be an attorney work product because we will be working on that report with the auditor, whoever that may be, who is completing the report and completing the audit on site. So, what this does is it gives us a much greater level of protection. Now, privilege such as these, they're not absolute, and there are things that go into that we'll discuss later on. How widely was it distributed? Did you maintain privilege with agents of the company or with only those people that were in need-to-know positions? But this is a big step in the direction of protecting what we have done. And, that is very good because, when MSHA comes out, now they say, well, hey, we know you did an audit. We want that, and you can tell them it's a privileged document. And if they want to get their solicitors involved to try and get that document at that point in time, they can do so, but they're going to have to prove to a court that that should be turned over and that it is not privileged, or that the privilege on it was deemed moot by distribution or by something that we did. So that is an important element, and it is really a good safeguard moving forward to protect it not only from the agency, but even if there is a civil action that comes, if we are involved in a serious injury or fatality, it's something that we can, again, assert that privilege that this was done for the purposes of legal compliance advice. And so that's an important element in trying to protect our audits. And to really make this work, it can't just be, we had this audit, we requested this audit from a third-party auditor, now we want to call our attorney and have him or her review it and give us some advice on it. To really get these protections and really put our best foot forward on any subsequent arguments related to the protection or the privilege, you should be getting that outside counsel to retain the consultant for you. And that's not to say that we get to choose who the consultant is, but we would set up that engagement so that, if need be, we could prove that, it was at our direction because we were the ones that retained the attorney, or retained the consultant to come out and do it. Additionally, we want to, or we should be having counsel involved in opening and closing conferences at the beginning and at the close of any third-party audit or any on-site audit. And that's going to be to go over some of the aspects of privilege and to, initiate the audit at the direction of counsel. And these might seem like procedural in nature, but, that's what we have to do and what we should be doing to, again, make the strongest argument later on that this was privileged and is protected, and the result should stay with us and shouldn't be spread beyond that. Also, when we're doing this, before the report is distributed, we need, or it should be sent to the attorney to review, and that's so the attorney can, edit it and be able to know what was found, and so that sound advice can be provided to the mine site and to the operator as to what conditions may need to be corrected, or maybe, if we're looking at it, we can say, well, this is not actually something that we need to do, maintain compliance. But that is an essential element of it. The report needs to come through the attorney. The attorney will then do their edits and do their due diligence on the results and then distribute that report out to company and site personnel. So once we have that, though, does anything else change? And with regard to the written report, and yes, there are changes in that we don't want to print out 100 copies of this report, leave them on every conference table and every break room table so that everyone can see them. We want to have a limited distribution, and these are going to be just to management personnel, and maybe not even to all management personnel, but just the management personnel that need to see it. So maybe it's just the health and safety manager at the site and the plant manager or the general manager, or maybe it is, multiple levels of people in the maintenance department who might be maintenance supervisors because they need to know or have input on what repairs are made or what repairs need to be made. So this is an important process, and you have to determine who needs to see the report and who needs access to the complete report. We also want to avoid, when we're doing work based on the recommendations in an audit, just handing out a copy or a page of the audit and saying, hey, here's this hazard, or here's this item that needs to be fixed. Go ahead and do it. Here's a page to show you what we think was wrong and what you need to do and where it is. We want to create new work orders. We want to create new tasks lists, whatever you want to call them, that don't include the specific language of the report and don't make direct reference to the report. And this is really trying to just take it a step further. Again, we want to distance ourselves from wide distribution of that report. Now, obviously, people always ask, well, who can we talk about this with? Who can we, tell people are going to know that an audit happened? Of course, and we have to work with the site personnel, and the auditors are going to gain the most valuable information through the site personnel. But we're looking at protecting that written document, that final written document, and what's included in that. So we don't want that whole document to become discoverable and lose its privilege because we just ripped a page out of it and gave it to a maintenance person and asked them to go make a certain repair. You can certainly just type that up or tell them verbally, hey, go repair the guard on this piece of equipment, without showing them the exact report or showing them a copy of the full report. So you want to make sure that we do this so that we are, again, trying to protect what was out there and what we have in terms of a privilege report. Because once we break privilege on a single page of it, the whole thing, it kind of, is a chain link. When we bring one chain, the other ones begin to crumble. And so we want to be sure that we're doing everything we can to protect the item as a whole. And that's what I often tell people is we're looking at what can we do to protect the entire report, not just a page of it, not just the things that hurt us, but the entire report. Obviously, we don't want MSHA to get access to anything that could adversely affect us from a compliance perspective, or that could adversely affect us from a negligence or employer knowledge perspective. But in doing so, we also want to make sure that, we are just keeping everything together, because distributing the and we don't want to say harmful, but maybe the non-questionable items will destroy that entire document's privilege. Privilege is very strong protection, but it also can be fragile in terms of it can be broken relatively easy if we distribute it widely, and if people who are not subject to that privilege distribution gain access to it. I wanted to take some time today as well to talk about a couple other changes that are going on with MSHA, or maybe some updates, because I think it's important, aside from the audit program, to stay on top of what may be changing with the agency. And one such item that goes back to record keeping, goes back to listing items that may be adversely or adverse to our knowledge or may cause record-keeping concerns, is the workplace exam rule. And this rule, obviously, the new workplace exam rule for metal non-metal mines has got a lot of attention in the last 8 to 10 months since it was finalized in January. And also, obviously, much more before that when it was in the pre-rule and the comment period. And the reason I bring it up is because we are less than 2 months away from when it's supposed to go effective. Now, it's been delayed several times since it went final in January, and it could very well be delayed again. But, at this point, operators need to begin to prepare for what could be an effective date of October 2nd. They need to know that there are changes coming to the workplace exam rule, and those changes include that the workplace exam rule must now be completed before work takes place in any area. Previously, it was that workplace exams had to be done once per shift. So people could work in an area for a while before the workplace examiner got over to see it, or maybe your established policy was to conduct workplace exams at the end of each shift. I'm not sure, what each company obviously does for their workplace exams, but now, before any miner can access an area to begin work, or before they can begin work in an area, the workplace exam must be completed. And this is obviously going to be a logistical item that all operators need to figure out how to deal with, because it is going to create a bit of a roadblock or maybe even a bottleneck for beginning the workday. In addition to this, we must also notify miners of any adverse conditions that are in a workplace that they may be going to. And that brings up a lot of questions: what's going to qualify as adequate notification? Is it verbally telling everyone before they set out for the site when you're giving out tasks during that day? Or does it need to be something more, such as, documenting it on the bottom of the workplace exam where, you have documented the defect or the adverse condition? Maybe having a little signature block saying this person was notified of the condition, or these persons. These are questions that, MSHA was supposed to be preparing compliance assistance materials, and, they really have not done a great deal in that, because I don't think they believe at this point in time that it's going to go effective on October 2nd. The last MSHA person or MSHA district official that I spoke to on this said that they were told the rule was on pause until told otherwise. So, it could very well get extended again, or as of Monday, there's a new acting head of the Mine Safety and Health Administration. His name is Wayne Palmer, and he was previously the Chief of Staff for the new Secretary of Labor, Alex Acosta. And he just took over. He does not have to be confirmed by the Senate because he's the acting head of MSHA. He's not the actual presidential appointee. And, up until this point, we've only had really the career people, the holdovers from the, previous administration directing the agency. And, they obviously have not been given the green light to enforce the workplace exam rule, or they would have already. But, we also are looking at how might this appointment or the new acting head of MSHA, how might that affect things? So, because we have seen a significant spike in enforcement in the last 8 months. There really has been a big pickup in enforcement around the country. And, that could change. Maybe it won't change. Maybe it's just a placeholder. Most rumblings say that there is going to be a formal nominee for the Assistant Secretary position this fall. We'll see if that's Mr. Palmer or if it's someone else from industry. One thing that many people seem to have picked up on is, it's not really readily apparent right now if he has any history in the mining sector or the mining industry. He, seems to be political, has his experience with some senators, and then as well as a lobbyist, and now with the transition team and acting as Chief of Staff for the Secretary of Labor. But there's not much out there in terms of actual mining experience, and that may not be a bad thing in terms of running the agency if he takes the direction of those people with that experience and listens to industry, which would be the hope. But we'll just have to wait and see how that pans out in the next couple months. Also, as part of that increase in enforcement, one item that has really picked up, especially over the summer, has been citations on silica exposure. Now, we all probably have heard about OSHA's new silica rule that has been finalized, is getting litigated, and is set to go into effect over the next couple years, depending on your industry. And prior to the end of the last administration, MSHA really was pushing to do their new silica rule as well. And that didn't happen. It seemed at the end they kind of maybe traded the workplace exam rule for the silica rule. Maybe they thought it would be less controversial. But they kicked through that workplace exam rule pretty quick, and the silica one kind of went by the wayside. But what we're seeing is MSHA enforcing not a new rule, but just really enforcing what is the existing standards very strictly. And they're doing more testing. They're going to do health sampling once a year anyways, but they're doing more testing, and when they do find a citation for silica exposure, they are requiring much greater efforts by operators to terminate those citations. I've talked with some MSHA personnel, and they said that it's going to not just be a fix that specific hazard or fix that leak and move on. They want to have both a long-term and a short-term action plan from the operator to prevent silica exposure at that site before they will terminate a citation. And it's also important to note that, unlike a citation with a guard where you can just, put the guard back on and or repair the guard and you've evaded and terminated the citation by the end of the inspection, these are ones where MSHA has to come back out and retest. And, if they come out and they test you on the day when there's another overexposure, you get an extension, or you could get a 104B order and get shut down over it. So they're really picking up on the silica citations. They're being very strict on what you have to do to abate the condition. I had one client who never had a silica issue. They got a single citation, and until that citation was terminated, MSHA wanted a mechanic who's never had a history of silica exposure to wear a respirator at all times. Well, that was difficult given, what the person was doing and where they were doing it. And I think that was a bit overstepping what was actually required, and we did push back on it, but they're being very strict in what's coming down. So if we are doing our own testing, which we should be doing, especially if we are in an area where we know silica exposure is a risk, we have to be doing enough testing to determine if our efforts are sufficient or adequate to avoid that overexposure. We want to make sure that we are prepared when this happens, because MSHA is not going to just vacate these and walk away. That's just one of the enforcement trends that I've seen that has picked up quite a bit of steam lately. So when we're looking at this, just kind of a conclusion on things, we want to be careful about the language we use to describe findings or recommendations. We want to avoid using terms such as violation, or this is a hazard, or this is a required action to maintain compliance. Phrasing like that we want to stay away from. And additionally, if we are creating a written report of findings, we want to quickly address them. And I mean that as in we want to quickly correct them, take action to correct them, or if we determine that no further action is necessary, we want to be able to provide reasoning why that avenue was taken, or why we did not take any action on the recommendation. And then lastly, obviously I think if you really want to privilege your program, if you really want to protect that report as best you can, you should consider engaging outside counsel to manage that and to review it and to, create that privilege. Because that is really, when we're looking at it in the sliding scale, the best avenue to explore to protect that and to protect the results of any audit. So, with that, I appreciate everyone joining today. If you have any questions, I'm happy to take them. You can type them into the box at the bottom, or feel free to let me know at any time by email or anything along those lines. Please, if you're interested, check out the MSHA Defense Report. We, post blog updates on changes in the industry, whether that's enforcement or case law or developments like the new acting director or acting head of MSHA. But yeah, if there's any questions, I'm happy to take them. And if not, I appreciate everyone joining today. And please join me next month for our webinar on managing MSHA inspections. All right, it doesn't look like there's any questions, so I will let you all go. And as I said previously, I will distribute copies of the slides as well as a recording of the webinar in a few days. So thank you very much. Everyone have a great day.